Item number 3 is by Senator Miller, Senate Bill 23 Sub A, an act relating to insurance, individual health insurance coverage. Chairman Miller.
Thank you. Just as we saw last year when the Supreme Court overturned Roe v. Wade, enacting protection at the state level is the only way to truly guarantee the rights and protections we want Rhode Islanders to have. We codified these protections at the state level in 2019. We should do the same with the rights afforded by the Affordable Health Care Act, which has been targeted since it passed in 2010, and which remains the subject of litigation concerning preventative care requirements. We want to ensure that Rhode Islanders have these critical protections, so we need to put them into state law. This would enact in state law protections including prohibitions on insurers denying coverage due to pre-existing conditions or refusing to issue or renew an individual's policy, protecting them even if they are sick. It would protect the requirement that preventative services must be covered with no cost sharing, and the requirement that insurance policies cover the 10 essential benefits, which include ambulatory patient services, emergency room services, hospitalization, maternity and newborn care, mental health and substance use disorder services, including behavioral health treatment, prescription drugs, rehabilitative and habilitative services and devices, laboratory services, preventative services, wellness services, and chronic disease management, pediatric services, including oral and vision care. Senate Bill 23 codifies the current status quo of the Affordable Health Care Act into Rhode Island law. This includes the religious exemption at issue in United States Supreme Court known as the Little Sisters of the Poor versus the Commonwealth of Pennsylvania. That decision affirmed the Trump's administration regulatory exemption for religious entities. The current administration has not reversed or amended the religious employer exemption. The exemption remains in law, no matter what you've heard to the contrary. And those arguments are inaccurate if they misled you. On behalf of quality insurance for Rhode Islanders rather than insurance company profit, I move passage of Senate Bill 23.
Chairman Miller moves passage of the act. Second by Senator Oyer, Senator Sosnowski, Senator Brito, Senator DeMario, Senator Acosta, Senator Zuria, Senator Gu, Senator Lawson, Senator Mack, Senator Cano, Senator Coleman, Senator McKinney, Senator Burks, Senator Bell, Senator Lamont, Senator Jafusa, Senator Loria, Senator Murray, Senator Casada, and Senator Valverde. Discussion on the act. Senator DeLuca.
Thank you, Mr. President. I'm going to propose floor amendment 000285/2.
Senator DeLuca proposes the amendment LC 00285/2. Is there a second? Second by Senator Morgan and Senator Dela Cruz and Senator Paolino and Senator Rogers. Discussion on the amendment. Senator DeLuca.
First, I think it's important for a brief procedural history. As a result of challenges of religious exemptions and accommodations for coverage of certain preventative services under the Affordable Care Act of 2010, the IRS, the Federal Department of Labor, and Federal Department of Health and Human Services promulgated 2 administrative rules in 2018. The first administrative rule, which was promulgated, was to expand an exemption by religious institutions to include an employer who objects based on its sincerely held religious beliefs to its establishing, maintaining, providing, offering, or arranging for coverage or payments for some or all contraceptive services. The second administrative rule, which was promulgated, was a similar moral exemption for employers with sincerely held moral objections to providing some or all form of contraceptive coverage. The Commonwealth of Pennsylvania sued, and the case ended up in the Supreme Court of the United States. The case, commonly referred to as the Little Sisters of the Poor case, was decided in July 2020, and essentially, that SCOTUS case held that the IRS, Department of Labor, and Department of HHS, in the authority to promulgate the religious and moral exemptions to the Affordable Care Act. With that history, let me explain the amendment. I propose the following language be amended to each of the three places that the preventative services mandate in Senate Bill 23 sub A appears. I won't read the proposed language 3 times, but this is the paragraph my amendment proposes to add. Notwithstanding any other provisions of this section, any insurance company may issue to an employer, an individual or group health insurance contract, plan, or policy that excludes coverages which are contrary to the employer's bona fide religious or moral tenets. As used in this section, contrary to the employer's bona fide religious or moral tenets means an employer that asserts that providing or funding such coverage would be contrary to the employer's religious beliefs or moral convictions. Every employer that invokes the exemption provided under this section shall provide written notice to the prospective enrollees prior to the enrollment with the plan listing the healthcare services the employer refuses to cover for religious or moral reasons. My proposed amendment separately recognizes both religious tenets and moral tenets because we are attempting to follow, in far fewer words, the federal exemptions. For these reasons, I ask you to support my amendment. Thank you.
Thank you, Senator. Chairman Miller.
So I plead for you to vote no on this amendment. We have a very disciplined approach to this legislation in which we strive to do nothing other than codify and have it triggered by any attempt to destroy the ACA in any federal action, whether it be executive, congressional, or Supreme Court. The language proposed in this amendment goes way beyond that. It has no discipline. It has nothing to do with codification. They should strive for legislation. This is legislation. This amendment is legislation to go beyond codification, to include way beyond what we would do in legislation that was responsibly codifying and protecting, rather than going on to beyond that. And I plead with you to vote no on it.
Well, thank you, Mr. Chairman. Further discussion? We are on the amendment. Senator Dela Cruz.
Thank you, Mr. President. I would plead with you to vote for the amendment, and I rise in support of this floor amendment that was brought forth by Senator DeLuca. It is important to note that the federal contraceptive mandate, now proposed as a state mandate in this bill, has been challenged not only by the Little Sisters of the Poor, but also by Hobby Lobby, Notre Dame University, Eternal World Television Network, and dozens of others, including nonprofits and family-owned businesses who have had to defend their First Amendment rights all the way to the Supreme Court for a better part of 10 years. And while Senate Bill 23 sub A manifestly codifies the federal mandate into state law, it does not codify nor even reference in any way whatsoever the religious exemptions or the moral exemptions from which the federal mandate that was promulgated in 2018 by the Department of Health and Human Services, the Department of Labor, the Department of Treasury, and upheld in 2020 by the Supreme Court of the United States after 7 years of litigation. This bill creates a Rhode Island stamp mandate that tramples upon the rights of the Little Sisters of the Poor right here in Pawtucket and other objecting Rhode Island employees, including religious organizations, nonprofits, and family businesses, by forcing them to participate in the deliberate taking of innocent life in violation of their own conscience and deeply held religious beliefs. It is shameful that this state, this great state, founded by Roger Williams as a refuge for liberty of conscience, would seek for even a moment to impose such a mandate without these exemptions. And for these reasons, I support Senator DeLuca's amendment, and I would support the bill if it was amended with this language. Thank you.
Thank you, Madam Leader. Senator Bell.
Thank you so much. I rise in opposition to this amendment. I think it's worth talking a little bit about what the amendment would actually do. The way it's worded, as Chairman Miller said, is extremely broad and goes way beyond the intent of this legislation. It would allow an employer with basically no restrictions to deny coverage on any moral conviction whatsoever. As I read this, this would allow, for instance, an employer to decide to exclude coverage to same-sex spouses. And I think it is plausible some employer might want to do that. It would allow denial of coverage for any reason that counts as a moral conviction. And I think it's also worth noting that this issue that we're talking about is about a very narrow and specific debate, which is the Little Sisters of the Poor case originating the question of whether hormonal IUDs or Plan B count as an abortion. And I'm not going to delve into that debate, but this is about a very narrow question about certain types of contraception. It is not, at least as described, intended to be about such a vast and expansive thing as is in this amendment. And so with that, I would urge people to vote against it.
Thank you very much, Senator Bell. Senator Leader Pearson.
Thank you, Mr. President. I just want to rise quickly and say that both Chairman Miller and I think Senator Bell hit the head on this mark. Just knowing this, the standard would be that the employer simply has to invoke the exemption by providing written notice to prospective enrollees on not covering any coverage. It could be a coverage for heart conditions. It could be a coverage for broken legs. All they have to do is send a letter, and they don't have to cover it. And so this amendment goes way beyond, I think, even the intent of the amendment, and I urge my colleagues to defeat it. Thank you, Mr. President.
Thank you, Mr. Leader. Further discussion on the amendment? Hearing none, the clerk will please unlock the machine. The 4 members have cast their vote. The clerk will lock the machine. There are 10 votes in the affirmative, 25 against. The amendment fails. We are back on the bill. Is there discussion on the main bill? Hearing none, the clerk will please unlock the machine. Madam Leader.
Thank you, Mr. President. Glad I got in there under the wire. I might change some minds. I sat in committee and heard plenty of testimony.
Excuse me, we're going to clear the board and then you can continue.
Yeah, sure.
Madam Leader, please clear the board.
Okay, will do. Thank you, Mr. President. Yeah, I sat in committee and heard lots of testimony regarding this legislation. And as I heard some of the senators testify in favor of this legislation, I'd just like to point out that if we're going to codify the federal law, then let's codify the exemptions as well. And so if we're not going to do that, then I don't think we should be cherry picking which parts. If we're saying that we're going to codify this into state law, let's codify the whole thing, including the exemptions of those who have deeply held religious beliefs. And so for that reason, unfortunately, there are merits to this piece of legislation. I would like to vote for it, but because it's flawed fatally, I cannot. And so I would ask and urge my fellow colleagues to consider those with objections, both morally and religious, to vote against this legislation. Thank you.
Thank you, Madam Leader. Chairman Miller.
I want to make it clear one more time what codification means. Codification means we're codifying the ACA as it stands. And as it stands includes the Supreme Court decision around Little Sisters of the Poor. So that means codifying the Trump administration's regulatory exemption for religious entities. The current administration has not reversed or amended the religious employer exemption. The exemption to allow what the minority leader wishes is being codified. It is part of codification. That what she is asking for is codified.
Thank you, Mr. Chairman. Senator DeLuca.
Would the sponsor yield to a question?
Will the sponsor yield to a question? I believe he will.
My question is, where does it say in your bill anything to do with religious exemption? Where does it mention those words, religious exemption?
In codifying existing law, we are codifying the Trump administration's language and the Supreme Court's decision, which goes directly to the exemptions which you ask about.
That it codifies the exemptions that I already asked for. What is the harm in saying, yes, these exemptions are already in place, so thereby, let's just put it in state law. You claim that it's in federal, right? You're saying that it absolutely does it, there's no reason to do it, so why not be specific and say, we know, you're saying we know that in federal law codifies these exemptions. All I'm asking is, if we know, we're absolutely positive, what's the harm in writing the simple words that we know that we're entitled to by the Constitution? Thank you.
Thank you, Senator. Senator Zoria.
I have a question for the sponsor, please.
Will the sponsor yield to a question? I believe he will.
Okay. On page 8, subsection B, I read it to say the following. If any provision of the federal act and implementing regulations relating to coverage for essential benefits and/or services are determined by the commissioner to have been repealed or to have been declared invalid or nullified by final judgment of a federal court, applicable to the state or be by executive or administrative action, which shall be deemed to include an action of the federal executive or judicial branch that nullifies the effectiveness of the obligation to provide coverage without cost sharing for a meaningful range of preventive services substantially similar to those, then the following shall apply. Is that the section that you're referring to that picks up the court rulings and other exemptions in the Rhode Island Act?
Yes, in addition to that, if you read the full ACA, which of course we do not have in front of us, the full ACA incorporates the Supreme Court decision.
Okay. Thank you, Mr. President.
Senator DeLuca, you have spoken twice. Senator Morgan would like to yield her time to Senator DeLuca. Please proceed.
Thank you. Again, I'm not a lawyer, so I can't keep up on all the legal jargon that much. But any person that reads my amendment would understand fully that their rights are protected in the state of Rhode Island, where religious liberty was founded in the state. And it's not much to ask. If you claim that these rights are already protected in your bill, then you should not have zero problem writing the plain language that everyone can understand. And I don't understand what the issue would be if you claim that it's already in the bill. Thank you.
Thank you, Senator DeLuca. Further discussion on the act? Madam Leader.
Thank you, Mr. President. You know, I hate to belabor the point, but unfortunately I must. There are certain pieces of legislation where I feel it's important to really press the point here, and I think that Senator DeLuca made some excellent points. So let me make it clear one more time. Why don't we err on the side of caution? If there is question, why not plainly state it? You have two lawyers in a room, read over a piece of legislation or law, and come out with 5 different opinions. Let us plainly state it so that there is no question whatsoever to the intent of the bill. Thank you.
Thank you, Madam Leader. Further discussion on the act. Senator Bell, for the second time.
I believe it's the first time on the act, but anyway.
Right, I stand corrected, Senator.
I won't get up again, don't worry. So, would the sponsor yield to a question?
Will the sponsor yield to a question? I believe he will.
So, I have the opposite concern as our colleagues in minority party have. I'm concerned from reading this language that it may go too far. And I guess my question is, what would happen if additional language were repealed or nullified by a federal court order? And the other question I have is, why shouldn't we reverse the Little Sisters of the Poor decision? To me, I think it's poor public policy, and you know, it's already an erosion of the Affordable Care Act. And to me, I think a good spirit would be to preserve it as it was before interference from the Trump administration. So those are my questions.
You have the floor, Mr. Chairman.
Like Senator DeLuca's amendment, which should be legislation rather than an amendment, because it goes well beyond the Sisters of the Poor ruling, to Leader Pearson's response. Your proposal is another piece of legislation, which I would probably support. But what we have in front of you today is maybe a more conservative approach than what you would take. And I encourage you to submit that legislation at a future date.
Thank you so much, Mr. Chairman.
Further discussion? Senator DeLuca, you've spoken before. Would you like to yield? Senator Paolino would like to yield his time to you. Please proceed.
I would just like to say thank you for supporting my amendment.
Any other discussion? Hearing none, the clerk will unlock the machine, please. If all members have cast their vote, the clerk will lock the machine with 28 votes in favor, 9 against. The act passes.